Module F, Organizing the Brief. In a presentation with former Minnesota Chief Justice Eric Magnuson, he spoke about how after working as an appellate judge, he couldn't emphasize the following items enough when it comes to how you approach appeals. First, keep your writing simple, focused, and have a point. Appeals are different than writing for the trial or the district court. Put it into context. To whom are you writing? Start with your conclusion first. It's important to have a message and to build off of it. You also need to know where you're going right away. When it comes to actually writing the brief, choose a few strong issues. Pick a theme beginning with your statement of the issues and carry it through the rest of the way. And most importantly, remember to have a point. Every case needs one. When it comes to choosing a theme, there's several things that you have to think about. The first and most important ingredient of any good story is the theme. Movie storylines based on weak themes are an invitation for critical and commercial disaster. The same is true for appellate briefs. If you were writing a fiction story, you'd probably address what the moral of the story is. What lesson or lessons would you want the reader to learn from your writing? What, at the most basic level, is the story about? When you apply this to your brief, you're basically asking yourself, what is the bottom line? What are you trying to prove? Why is your client's cause just? Or why is the other side's cause unjust? Every part of the brief needs to support the theme, the facts, the headings, the introduction summarizing the argument, explanation of governing law, key facts, and the question presented. What overriding message is the document going to convey? What facts are essential to the argument? How does the argument take off from the facts? How do different arguments blend together? You need to consider all of these questions and more as you start to craft your theme. If you were at a bar telling a friend about your case, what would you say? How could you summarize it in a few sentences? The best theme for a story is not a legal issue at all, but a commonly held premise or belief, something most people believe in and with they can identify. For example, one appellate attorney has been very successful crafting themes based on the best-selling book, All I Really Needed to Know I Learned in Kindergarten, by Robert Fulghum. In a case involving a purchaser's lawsuit against a seller to recover the costs of environmental remediation, the attorney deftly adapted Fulghum's principle that, if you mess it up, you clean it up. Similar universal themes can be drawn from the Bible, children's stories and fairy tales, commercial slogans, and even movies and books themselves. And it may, in some cases, be appropriate to have secondary themes for secondary issues or parties. You all probably remember, if the glove doesn't fit, you must acquit. I'm not expecting a slogan quite like that, but if you create a solid theme, it will resonate with your reader, the judge. A brief should have a strong opening, forcefully but concisely stating the argument. This opening will have your theme. The opening can be an introductory paragraph or in the summary of the argument. If you get the reader to decide in the introduction that you should win, you have the entire brief to explain why. Let's talk about organization a little bit more specifically using a hypothetical case. Let's say when you are responsible for writing a brief in a hostile work environment case where an employee complained of sexual harassment and the employer disciplined the perpetrator. You represent the employer, who for the purposes of our hypothetical is the city. The introduction. Remember, your goal is to educate the reader from the start. The use of a summary or roadmap of the arguments in an introduction or the summary of your argument is helpful. Summarizing before you launch into detail will let the court know where you're going. Be sure to lead with your strongest arguments. You don't want to bury your lead. Use your theme to help introduce the idea. For example, Title VII holds employers responsible for their own discriminatory conduct. It does not hold employers responsible for every incident of harassment committed on their premises. You're probably familiar with the IRAC format when writing essay questions. You'll want to follow a similar format when making legal arguments. It's called CRAC or CRAC. Conclusion, rule, application, conclusion. For each major point you make throughout your persuasive brief, you'll want to start with the conclusion rather than the issue. Summarize how the law applies to your facts. What legal conclusion do you want the court to reach? That's what you're including here. For example, there was no hostile work environment in this case because the undisputed facts demonstrate that the city took adequate remedial measures when the plaintiff complained about sexual harassment. Next, outline the rules. Explain the proposition upon which you will rely. For example, in our hypothetical, you'll want to explain binding case law that sets forth the test for establishing a hostile work environment and explains how the courts define adequate remedial measures. After you've laid out your conclusion in a way that illuminates the issue and your rules, you'll move on to explain the application. How do the legal propositions apply to your facts? In this case, you'll describe facts on record that establish the city took adequate remedial measures. Explain how legal principles from applicable statutes and case law and factual similarities to the applicable case law compel the conclusion that the city took those adequate remedial measures. Distinguish your client's key facts from cases that did find a hostile work environment. Once you've explained the application, then you'll come back to the conclusion and reiterate the bottom line that you're advocating for. Since the city took adequate remedial steps in response to the plaintiff's complaints, there was no hostile work environment. After you've structured each of the major points you want to make in your brief using a CRAC format, you'll want to think about the overall organization. Here are a few tips that you can weave throughout your brief. Make logical relationships between ideas easy for the reader to grasp. Move from the general to the specific. This way, the reader can get familiar with the argument, but not be buried in the detail before knowing what the big picture is. Use headings and subheadings. Briefs with frequent headings often are more logical because of the discipline needed to organize the arguments into sections that are distinctively labeled. Effective headings will articulate your client's specific legal argument. For example, Smith's due process rights were violated when she was fired as a teacher without notice or hearing. Compare that to Smith's due process rights were violated, which is not nearly as effective. But do make sure that you do not have too many headings on the same level. The human can easily only comprehend 3 to 5 subdivisions of any subject, so you should not have more than 3 to 5 major headings. When I was working at the Court of Appeals, I had a property case that had 15 sub-issues under one of the major arguments. It was ridiculously long and convoluted. Even better yet, when the attorney appeared for oral arguments, he quickly conceded that only 2 of the sub-issues were even important. So why bother including the rest? Use, but do not overuse, bullets and numbered lists. If the legal test or argument can be logically presented in an enumerated list, help the court by listing that. Check overall flow by reading only the first sentence of each paragraph in your brief. Does it still, for the most part, make sense? As you're looking at your overall organization and logical flow, also be sure to check your transitions. The brief should march across the page. According to the head nod rule, the reader's head should start nodding in agreement at the beginning of the brief and continue nodding throughout the brief. If the head stops nodding, then there's a rough spot that should probably be addressed. Connect your sentences and paragraphs. Avoid general connections, such as further, accordingly, and thus. Make logical relationships between ideas easier to grasp by using in addition, by contrast, or in the alternative. For example, if the brief argues that the court lacks jurisdiction and then argues the merits, use a transition to signify that the arguments are in the alternative, even if this court has jurisdiction, or regardless. The topic sentence at the start of each paragraph should provide both transitions and mapping. Use pointing words, words that inherently reference a prior statement, such as pronouns, this, that, those. For example, John said X. In context, he meant Y. Or, the full credit bid rule is, applied to the facts here, this rule dictates. These types of things connect the 2 sentences together. Additionally, use parallelism or repetition. For example, John testified X. His testimony was critical. Testimony repeats testified and draws these things together. A great example of where a lot of parallelism and repetition is used is the Gettysburg Address. Also be sure to foreshadow in your transitions. For example, thus, foreseeability is necessary, but not sufficient to establish duty. For a duty to exist, other public policy factors must favor imposing a duty. The reader is left with the question, what are those factors? How can we examine them? This leads into the next sentence, paragraph, or section, which answers those questions.